So now moving into the last couple of sections. So we've gone through the law, we've seen what's in the law, we've seen the oversight and enforcement mechanism, we've gone through a comparison between CASL and CAN-SPAM. The last couple of sections are really intended to look at some of the meat and some of the practical implementation issues that might arise under CASL. And I should just say and throw another caveat out there, this is a new law. It does a lot of things. It's a complicated piece of legislation. Inherently, there are going to be a lot of questions, a lot of issues that come up in terms of how the law is going to be interpreted and applied. And to be brutally honest, we just don't know in a lot of cases. In some cases, we might be able to look to other Canadian laws or laws in foreign jurisdictions, such as CAN-SPAM or the anti-spam legislation in Australia and New Zealand. That might provide some interpretive assistance in some cases. Obviously, the enforcement agencies, and in particular the CRTC, is going to play a key role in this. The extent to which they might issue interpretive guidelines or how they're going to interpret certain provisions, how aggressive and active they're going to be at the outset I don't know the answer to these questions, so it's going to be really important to watch and see how the agencies interpret and apply the law. So with that in mind, no one is going to walk away today with all the answers, including me. So I think really the goal is to try to facilitate some discussion and identify some of the key issues so that when you go back to your own companies, you can identify some of the issues, speak intelligently about them, and raise some of the issues with your companies and your legal counsel. So first I'm going to deal with some of the issues that arise in terms of application, liability, and consent. And again, I should just throw out the caveat there that this is not in any way legal advice. So I thought I'd start it off with an interesting little anecdote. So this was an email that was sent back in February of this year. So this is an enterprising lawyer in Canada who recognized the potential opportunity for business development under the new law. He describes it's very scary. The CRTC is going to come after you. I have experience dealing with the CRTC, and this is not me, by the way. He's sending out this email. But I have experience, and I can help you. So if you get hit with a huge fine, call me, and I can help you with this. So this, from what I understand, this email was actually sent out to a very large number of lawyers across Canada. And this was a colleague of mine who is a lawyer. He doesn't actually practice right now, but he has a presence online and he has a website. So this lawyer came across his email address online and decided to send him this email. Some people might call it spam. Some people might call it clever marketing. I don't know how much business he's actually gotten out of this so far. So a colleague of mine wrote back, and I don't know if you can read this, but basically saying, thanks for your email, and I hope the irony is not lost on you that you're basically spamming me to advertise your services under new anti-spam legislation. And by the way, you didn't even get the name right. And then I love the response here. Well, the anti-spam amendments haven't even come into force yet, so I can do whatever I want, at least until that time. And then he offers his own interpretation of the implied consent provisions, basically saying that because you've put your address online, well, it's out there for the world, and I'm emailing you based on the implied consent provisions. So I'm covered under the implied consent, and if not, well, the law isn't enforced yet anyway, so there's nothing you can do about it. So not really as much of a legal issue as I think it's just sort of a funny little anecdote. Andre talked about this in one of the questions that came up under his section, and these are the considerations for non-Canadian senders. So I'm not going to go into this in a lot of detail. We can talk about it more if anyone has questions. CASL, obviously, as we know, applies to anyone who's sending into Canada as well as anyone who sends from Canada. And as we've identified, it's difficult, if not impossible in a lot of cases, to know if your recipients are actually located in Canada or not. And I would just like to return to one of the issues that came up in the question, and that is the concept of a due diligence defense. And so if someone has given you a postal address or any other information that might indicate that they're actually located in the US and not Canada, would you be able to trot that out as evidence in case of that you're brought up on a violation and you want to be able to say, well, look, I did my due diligence. He told me or she told me that they're located in the US and not Canada. And the only thing that I would say about that, and I've had conversations about this, I would caution people against doing that, because that particular defense that you'd be raising there, you're not necessarily saying, look, I took steps to try to comply with the law. You're saying, no, look, I took steps to try to make sure that I don't have to comply with the law. So I don't know how favorably a court would look to that defense if you were to bring that up. So I would caution people against just sending it out and ignoring the law based on the possibility or based on this information that you've received from the recipient, indicating that they might be located in the US and not Canada. And as Andre talked about, I think we can say that there's been a growing trend over the last maybe couple of decades where courts seem to be increasingly willing to recognize judgments that are issued in foreign jurisdictions. But I'm not an expert on this, but I know that these rules can vary significantly from jurisdiction to jurisdiction, so not even from country to country, but state to state. So I think that it would be unwise to assume that a private right of action cannot be enforced against you, but it doesn't necessarily mean that it's going to be in all cases. This is obviously a very important issue for a lot of people here, because we have a lot of service providers in the room and a lot of service providers who are members of MAAWG. And that question that Andre touched on a little bit in the response to the one question was, to what extent are service providers potentially liable for the actions of their clients? I think a good starting point is to look, we have this exemption under the legislation from Section 6, saying that the anti-spam provisions do not provide to a telecommunications service provider merely because the service provider provides a telecommunications service that enables the transmission of the message. So what does this really mean? We have a definition of a telecommunications service provider. Telecommunications service provider is someone who operates telecommunications facilities to provide telecommunications services. We don't really know exactly what that means. And again, this is another one of those issues that I think is going to be sorted out as we see guidance and decisions from the regulators. I think the most obvious situation where this is intended to apply is that for an internet service provider. So if you're an ISP and all you're doing is you're operating mail systems and you're delivering mail from one end to the other, I think it's pretty obvious that in that situation you shouldn't be held liable. And I think this is this is probably the most pertinent example that were in the minds of the drafters when they developed the legislation. But the extent to which this applies to email service providers, to me anyways, is much less clear. And some of the issues that I think that people will need to consider, it could depend on the types of services that you offer. So sometimes we see this distinction between full service and self-service. I don't know if this is the best way to distinguish, but if you're merely providing a platform and the client is responsible for developing the list and deployment, then I think in that situation you might be able to make an argument that you fall under this exemption. But if you're doing more than that, if you're going beyond, you're providing more guidance in terms of how to deploy campaigns, if you're actually involved in the list building process, then I think you'd be much less likely to be able to rely on this particular exemption. It's not the end of the story, though. Andre also talked about Section 9, which provides that it's prohibited to aid, induce, procure, or cause to be procured the doing of any act contrary to Sections 6 to 8. So again, this sort of speaks to the issues that the services that you're providing and what you're actually doing on behalf of the client. It might be less likely that an ESP would be seen as inducing or procuring or causing to be procuring an act. But you could potentially be seen as aiding a client if they're sending out spam. And the due diligence defense, I think, is probably quite important here. If you're brought up, if you receive a notice of violation or you're sued under the private right of action, I think the question that you need to be able to answer is, what did you do to prevent the commission of the violation? So what did you do to prevent your clients if you're not the one who actually committed the violation? And under this, we look at things like education and awareness. So have you made your clients aware of their obligations under the legislation? Obviously, you have to be careful there. You're not providing legal advice and guidance on how to comply with the law. So you have to be careful to make sure that you properly position that. But generally making them aware that the law is out there and that these requirements exist. Obviously, agreements are going to be important. So what's in your agreements with your clients? What did you tell them that they can do? What can't they do? What are the penalties? What are the consequences if your clients are not complying with the legislation or doing what they said they would do? And the willingness to fire clients. So can you show an agency or a court that in the past you've actually fired clients that were in violation of the law? And again, I can't say with any certainty that this is what the agencies are going to look at. But in my view, when I look at the legislation, I think these types of things would be important for service providers. Express consent. This is a really an issue that I get a lot of questions about. There are a lot of questions out there around express consent and exactly what it means. Just had an interesting discussion with a few people about this at the break. So express consent is not defined in the law. We don't know exactly what it is. The only thing that really is clear in the law, or the most important requirement, is that you must clearly explain the purposes for obtaining consent. So we know that when you obtain consent, you have to tell the potential subscriber exactly what they're consenting to. So are they consenting to receiving email messages? Are they also consenting to receiving text messages, potential instant messaging? Who will actually be sending the messages? So will they only be sent on behalf of you, or are they potentially going to hear from some of your partners? And who are these partners? And who is going to be sending those messages? Are you going to be sending them? Are you potentially sharing this consent with another party? All these things have to be very, very clearly laid out. The sender must obviously clearly identify themselves when they're obtaining consent. And if you're obtaining consent on behalf of another party, you also have to clearly identify who that person is. And Andre touched on this, but the onus is on anyone sending an electronic message under the legislation to be able to provide evidence of express consent. And this could be different things. This could be your logs of the sign-up process. Could potentially be transmission data of a telephone call. It could be a piece of paper where somebody checked a box at the checkout in a retail outlet. And then we get into the issue of exactly what express consent is. So we have all different versions of express consent. We have opt-in express consent. We have opt-out express consent, single opt-in, notified opt-in, double opt-in, and just to run through what these different concepts mean. Opt-in express consent generally refers to the fact that you have to undertake some sort of affirmative action. So this means that you actually, when you see the request for consent, whether it's in a sign-up page or when you're doing the checkout, that box can't be pre-checked. So it means that you actually have to check it. That's what opt-in express consent means. You compare that to opt-out, the box is already checked. So it sets the precondition that you're going to consent to receiving those messages. There's some debate and question over whether opt-out consent is sufficient under the legislation, and I don't think there are any certain answers at this time. The Privacy Commissioner has found that opt-out consent is okay for this type of thing. under the Personal Information Protection Electronic Documents Act, but that's a different law. And the agencies and the courts could take a completely different opinion under CASL. So if you single opt-in is just opt-in, you opt in, and then you're signed up to list, you're going to receive messages. Notified opt-in is where you sign up and then you receive a message notifying you that you've opted in. So before you receive any further messages, then you're then given an opportunity to opt out or unsubscribe. And then we have double opt-in, which is the gold standard that I think, well, some MAAWG members might advocate for this, that this is the best way that it should always be done. So someone signs up, they check on the box, they get a message confirming that they actually want to subscribe to that list, and then you have to take some sort of affirmative action, whether you're just clicking on a link to confirm that you're actually opting into that list. And also, this isn't a requirement under the legislation, but I think in a lot of cases it's a good idea to think about reminding recipients why they're receiving the message, particularly if the messages aren't sent on a regular basis. So if you're sending them on a weekly or twice a week basis, most recipients probably are aware of the fact that they've subscribed to your list. But if this is something that might only be sent once a month or even less frequently, it might catch recipients by surprise. So it might be a good idea just to remind them why they're receiving the messages. You consented to receiving messages from this company on this date, and that way, it could potentially prevent filing of complaints. So when we talk about consent, it's hard not to talk about different ways and concepts that people come up with to build their lists. I don't think there's many people in here that would disagree with the notion that purchasing a list is probably never a good idea. It's probably not going to work out well for you in the end. It's not necessarily a violation of CASL per se. There's nothing in there that says you can't buy a list, but then you have to be able to demonstrate that they've actually consented to receiving messages from you and not the person that built the list, assuming that the person that built the list even got consent in the first place. So very, very likely if you go out and buy a list, you're going to wind up violating CASL, potentially in a very big way, especially if it's a big list. You also have to consider the application of privacy legislation, because privacy legislation might prohibit you from going out and just buying a whole whackload of personal information from people who have not consented to providing that information to you. Email appending is another one of those practices that's potentially dangerous. You take a list of contact information and you merge it with a database with email addresses. Again, there's nothing inherently wrong with that under the legislation, but how you're ever going to be able to demonstrate that you actually had consent, whether express or complied or implied by doing that, is going to be a very difficult proposition. Also have to think about address harvesting, which is a violation of PIPEDA, so you can't go out and mechanically collect electronic addresses. And just the general warning, if it sounds too good to be true, 1 million email addresses for $300, it probably is too good to be true. It's worth talking about ways to be able to leverage your own list and be able to leverage other people's lists. I think we'd all agree that there's proper ways to do this. There's proper ways to send third-party offers to your own subscribers. You have to consider things like relevance. Is the content of the message relevant to your own subscribers? It's important to ensure that recipients know who the message is being sent from. Sometimes you receive a message with a brand on it, but you don't actually know who the message came from. And again, that type of thing is going to potentially violate other provisions of the law, and it's going to confuse consumers and potentially lead to complaints. And if you're sending third-party offers to your own list, or if someone else is sending your creative to their list, you have to make sure that the consent originally that was obtained provided for third-party offers. So we'll just stop it there. I assume that there'll be some questions when we're dealing with consent issues. So if anyone has any questions, please step up to the mic and remember not to mention your name or your company. There's some other practical operational issues that have come up under CASL since I've been dealing with it, and some issues that I think that are worth talking about. Hopefully will facilitate a bit of discussion at the end of this section. Just as under CAN-SPAM, CASL establishes identification requirements. We don't know exactly what is required at this point. We would assume that a name is required, a postal address, and a web address. The CRTC has the power to make regulations to specify what information is to be contained in a message. I don't know for a fact. I would like to think that there'll be some regulations on this topic, and just make it a little bit easier to know exactly what's provided in the message, what's required. One of the concepts that we see under CASL is this idea that a message is sent on behalf of another person. So there's requirements that come up when you're sending the message. Very simple, you need consent, you need to identify yourself. If you're sending the message on behalf of another person, and this question came up earlier, who exactly needs to be identified? And this is something that I've had a number of discussions about and thought about a little bit. I have my own ideas about who needs to be identified. And part of the uncertainty here is rooted in the fact that we don't actually have a definition of what a sender is under CASL. So under CAN-SPAM, it's pretty clearly defined. We know who the sender is. It's the person who actually initiates the transmission of the message. We would assume that our regulators will take a similar interpretation of who is actually sending a message under CASL, but we don't know that for a fact. So if the sender is the person who actually initiates transmission of the message, we'll assume that for the time being. Who are the other people on whose behalf the message is sent? So it's very simple. If you have just one list owner who has their own brand and they have their own newsletter that goes out and they work with partners and their creatives are in the newsletter, I think in that case it's fairly simple. But when you have potentially agencies involved and the agency is working for certain advertisers and they're actually procuring the services of a publisher who owns lists, well then, is the publisher then sending the message on behalf of the agency who's potentially sending on behalf of a network who's potentially sending on behalf of an advertiser? The way the law is written right now, you could argue that all of those parties need to be identified, and I don't know if that really achieves the objectives of the law or that really helps consumers if you potentially have 4 or 5 or 6 parties who are all identified in a message. And the question that came up earlier is whether an ESP or other service provider actually needs to be identified in the message. Again, my own personal view is that I don't think that was the intention of this provision. I don't know how helpful it is for the recipient to know which ESP actually provided the infrastructure that allowed the brand to send their message. But again, I could be wrong on that, and this is very much a matter of interpretation, and we're gonna have to wait and see how the law is applied in this regard. I think it's safe to say that in virtually every case, the list owner should be identified. So the list owner in this context is obviously the person who owns the list of subscribers, but that should be the person who you actually interacted in the first place to provide your consent. And I think that this is important. I think this does fit with the objectives of the law, is that recipients should be able to know who they consented to and who they're receiving the message from. I don't want to receive a random message from XY brand, but not know how it came to me, because in a lot of cases, I never gave my consent to XY brand. I might have given it to someone else, but that should be very clear in the message. And that person should be identified in all cases. Obviously, in most cases, the advertiser or the brand is inherently going to be identified in the message. But again, questions arise as to potential other parties and intermediaries and the extent to which they're going to need to be identified in the message. Had some questions about forward to a friend, and again, as with everything else, I can't provide a simple answer that you can take away with, but we can identify some of the key issues that will come up when you're dealing with forward to a friend and potentially share with your network type messages. Again, we have to go back to Section 9 that prohibits anyone who aids, induces, procures, or causes to procure the doing of any act contrary to Section 6. And this is really important to keep in mind if you're offering incentives. So whether you're offering some sort of rebate or points or whatever, based on the number of individuals to whom a message is forwarded, then in my view, you're potentially caught under Section 9 if you're causing those individuals to effectively spam their friends and contact lists. It's important, I think, to impose limits on forwards. And this comes up when we think about the exemption under subsection 6.5, which states that CASL doesn't apply to any messages sent between individuals with personal or family relationships. So that's another potentially relevant provision, is that you might be able to say, well, I told them that they can only send this to their friends and family. And in order to be able to rely on that, I think you need to be able to show that you've put limits, whether it's 1, 2, or 5 at a time. But if you're encouraging people to go out and send this to 200 of their closest friends, well, then I think it becomes a lot less reasonable for you to say, well, I told them that they could only send this to their friends and family. And again, when you get into those bigger numbers, you're potentially implicating Section 9, which is the extended liability provision. A lot of questions about how CASL applies to social networking and share to social. And one of the key issues that comes up here is when you look at the definition of a commercial electronic address, a commercial electronic message, it only captures electronic messages that are sent to an electronic address. An electronic address is defined under the law as anything to which an account may apply. So something that an individual takes an account on. So an email address is an obvious example. We have an instant messaging account. You can have an SMS messaging account. But if you're just posting something to your own wall, or potentially even to someone else's wall, it brings up questions about, well, are you actually submitting this to an electronic address? And it's much less clear than in the case of an email address. So some people have taken the view that if you're just using a share to social button in your messages, then you're potentially not even implicating CASL at all. Some business-to-business considerations, and we get a lot of questions about this. What impact is CASL going to have on prospecting and the ability to reach out to other businesses? First of all, there's no general exemption for business-to-business communications, and Andre talked about the 2 exemptions under subsection 6.5, and one of which is if you're making an inquiry or an application to someone else about their commercial activity that they're engaged in. And it's important to be aware that that exemption, effectively, the way I describe it, is it's a purchaser-to-vendor exemption. So I'm inquiring about purchasing something from you. I'm not advertising my products to you. That's the way that I interpret it. I know that there are some people who have looked at it and said, well, look, I'm going to be able to send out as many messages as I want because I can craft it to fit within this exemption. I think that would be very, very, very seriously misguided. I think that it's pretty clear on the face of that exemption what it's intended to do, and I don't think that agencies or the courts would have much sympathy for you if you tried to come up with your own creative interpretation. So that being said, I don't think that CASL kills the prospecting, practice of prospecting altogether. The implied consent provisions here are obviously going to be key. And Andre already talked about this, but we'll talk about a couple of them. The first is the conspicuous publication of an electronic address. This is the single most important provision in my view. So this allows you to go to a website or any sort of listing or publication that lists electronic addresses of individuals and then send a message to them. But again, as Andre talked about, The key condition here is that message has to be relevant to that person's business or official capacity. And this is going to be a really interesting issue to watch as we see the law apply and things unfold, is what does relevance mean and how closely relevant does it have to be? So could someone send me a message for legal publication? I think that would be fairly clear that it would fall under that provision. But could they assume that because I'm a lawyer that I have an office and therefore I'm interested in office supplies and send me messages for office supplies? I would think that that probably goes a bit too far. I think a lot of this comes down to common sense, but no doubt there are going to be some people out there who really push the boundaries, and that's going to make it really interesting for the rest of us to be able to sit back and watch and see what happens when they do that. Another point to keep in mind here, which is really important, is that you have to manually collect the addresses, whether it be from a publication or the internet. If you're using a bot to go out and crawl the internet to collect addresses, you're violating PIPEDA. So you're going to have to pay somebody to sit down and do this manually. Got some questions about existing subscribers. So what do we do about our existing lists? You know, I have a list with approximately 150,000 people on it, and I'm not really sure the status. I don't have any records showing that they gave consent, but I keep sending them messages and I don't get any complaints, so what should I do? Obviously, the first question is, do you have evidence of express consent? Well, if you don't have evidence, and you keep sending to this list after the law comes into force, then you will be violating the law. Unless for some reason you happen to fall within one of the implied consent provisions, but you can't rely on an assumption like that. So some people ask and say, well, can I just send out a message, you know, confirming consent, opt-in consent? And technically speaking, and I'm not telling people to do this, but technically speaking, if you send out a message requesting consent before the law comes into force, and as long as they give you consent before the law comes into force, well then there's no reason why you can't keep sending. But it's absolutely essential that any person who does not respond or does not give you opt-in consent by the time the law comes into force, you have to stop sending to them immediately because you'll be violating the legislation. You know, if express consent is required, or if you're not certain about your records, or you know that they've given consent, but you're pretty sure that if you are served with a notice of violation, your evidence isn't going to be up to par and you're not going to be able to demonstrate it very well, well then you definitely should send out a confirmation message and get consent. You know, consider, you know, in a lot of cases people just don't respond to these messages. They can be very low response rates. There's nothing that says that you can't offer some form of incentive for people to respond, offer some sort of new campaign feature, new granularity in terms of what people are consenting to, or develop a new marketing preference center, and then use this as an opportunity to get people's consent to then keep sending when the law comes into force. I just put this last bullet on this slide. Probably not the best place to put it, but I think this goes without saying, but you know, consider the incentives for marketing departments. So if the incentive for your marketing people is to just get as many email addresses as possible, well then you're creating incentives for people to build lists that are potentially not consent-based. Consider changing those incentives to focus on the effectiveness of ad campaigns and not just sheer volume of email that's sent out. I know that it's easier said than done, but this is an important point in so many ways. I had some questions about the unsubscribe requirements at the break. As I mentioned, as the law is currently written, the obligation to process an unsubscribe request arises when the unsubscribe request is sent and not received. Again, this is potentially a difficult requirement for some people to comply with. I don't know if the due diligence defense might come into play there if for some reason the unsubscribe requests aren't getting through and you can show that it wasn't your fault. I know that there was a case under CAN-SPAM, I don't recall the company, who was actually found to be in violation of CAN-SPAM because their spam filters were actually blocking all the unsubscribe requests. So this is an important issue to keep in mind. Again, the request must be implemented without delay, and the best practice, and I think the safest way to interpret what without delay means, is that once the request has been sent, in this case, that no further messages are sent. And I had a question about this at the break, and I think we'll talk about it a little bit more, but in most cases, I think it makes sense that the list owner should be responsible for processing unsubscribe requests. There's very specific rules dealing with the multi-party messages sent under CAN-SPAM. The FTC has developed specific rules on that. And I think those rules, while obviously they have no impact or effect in Canada, I think the rules generally are pretty common sense.
Sean Brown and Andre Leduc.